How did indirect patent infringement evolve? Imagine trying to stop a crime, but the person you're after isn't the one directly committing it. Instead, they're helping or encouraging others to do it. That's kind of how indirect patent infringement works. It didn't just pop up overnight. It grew out of court decisions in the 1800s. Back then, judges started recognizing that someone who supplies a part or helps someone else infringe a patent could be held responsible. This idea was not written into law right away, but courts used case law to shape it. Later, in the year 1952, Congress passed the Patent Act, which made these ideas official law. They created two main rules, one for contributory infringement and one for inducement of infringement. Contributory infringement happens when someone supplies a part that has no real use except to infringe a patent. For example, if a company makes a special component only for infringing products, they could be liable. Inducement is when a person actively encourages or helps another to infringe a patent. Think of it as persuading or guiding someone to break the rules. At first, courts were cautious. They recognized these doctrines through case law, but sometimes limited their scope. They worried about patent misuse, which is when patent owners try to unfairly extend their rights. The law changed in 1950 to clarify that people who help infringe can be held responsible, especially if they know about the patent and intend to cause infringement. Over time, courts looked at related areas like copyright law. In the case of MGM Studios versus Groksta, the Supreme Court said that inducement liability requires purposeful encouragement. This meant that someone must intentionally help infringe, not just accidentally or unknowingly. This decision influenced patent law, making it clear that intent matters a lot. Today, indirect infringement is key in patent cases because it allows patent owners to go after not just the direct infringer but also those who supply parts or encourage infringement. This is especially important in complex tech fields where many companies and individuals might be involved in making or using patented inventions. So, the story of indirect patent infringement is one of gradual development. It started with court decisions in the 1800s, was written into law in the 1950s, and has been shaped by court rulings since then. It helps protect patent rights by making sure those who contribute to infringement can be held accountable, keeping the system fair and balanced.